Hi everyone, we are going to be discussing child custody law. There is probably not a family in America that has not been touched by issues of child custody, whether we're talking about in a divorce situation, a separation situation, or in a paternity suit. And so we are going to cover what the child custody laws are all about. We're going to cover the definitions of child custody. We're going to look at the types of child custody, and we're going to look at how the states make this determination. And so a lot of people tend to think that the custody decisions are sort of murky and that there's some mystery surrounding it. We're going to demystify the entire thing, and hopefully if you'll get something out of this, and if you want to share it with family members and friends so that they can have a little bit more information, that might be helpful for them. This is Dr. Tracey McCarthy, psychologist, attorney, and educator, and let's get rocking and rolling here. So let's start off talking about what child custody is. What is that all about? So when people go to court in a divorce situation, or they are separating, or there is a paternity action, there is, of course, this issue of child custody that comes up. And what custody is essentially is it's really just about the care of the child, the protection of the child, the supervision of the child, the control and the safekeeping, the guardianship of the child. And so that's what custody is all about. And so it's sort of tied into not just rights, but responsibilities. And so it's the right of the parent to provide the things that you see, but it's also the responsibility of the parent. And so what the courts are determining when they are making custody determinations is, who is going to be responsible for things such as care, protection, supervision, control, and safekeeping. And then also, whose right is that? And the courts that are usually involved, depending on the state that you are located in, it will be usually called family court, or in some instances, it'll be domestic relations court. As a quick reminder, if this video appears anywhere other than the Dr. Tracey McCarthy channel, it is stolen and unauthorized. Now let's address the primary types of custody. There are two primary types, and often people get confused about these two types, and so we're going to go over them in such a way that it'll be expedient and you'll understand it very clearly. So there are two types. You have legal custody and physical custody. Now what happens is sometimes a person will get legal custody, but they won't get physical custody, and it gets a little confusing for them. What this basically means is legal custody is the right to make decisions regarding health, education, and welfare for the child. Sometimes one parent may have legal custody, meaning that sole decision-making power. And sometimes there will be joint legal custody where both parents get to make determinations regarding health, education, and welfare. Then you have physical custody. And physical custody is basically a parent's right to have the child physically in their possession, physically in their home, residing with them. Sometimes a parent will have both. Some form of legal custody and some form of physical custody. Sometimes, however, they may have legal custody, but they may not have physical custody, and there may be visitation instead of the custody. Or sometimes they may have no visitation at all, and they may have no legal custody. And so we're going to talk about the different ways that the custody sort of works out. And just a little caveat here, oftentimes parents go into the custody situation demanding sole legal and physical custody, and this is an unusual dynamic where that would take place. Oftentimes when there's sole legal and physical custody, when one parent has all of that, it's because the other parent is unavailable or is totally uninvolved, or there's some serious problem going on with the other parent that would present a danger to the child. But in a general sense, there's usually something less than sole physical and sole legal custody that an individual parent gets in a custody action. Now, what you see here is a sort of layout. You can see how the legal and physical custody work together. And so you have different types. So you can have sole custody, and that means one parent. So if you have sole legal custody, that means that you have sole decision-making authority. If you have sole physical custody, that means you have the singular right to have the child in your possession in your home. If you have joint custody, that means both parents. And sometimes you'll have joint legal custody and joint physical custody. That means that both parents have legal decision-making authority and both parents have the right to have the child in the home with them. Then you have what's known as split custody. Now, split custody also involves both parents, but it's actually where the children are split. And so you may have, let's say you have a large family. So let's say there are 8 children. It's a large family. And so what the courts might do is do a split custody situation. So let's say there are 4 girls and 4 boys. On Monday, Tuesday, Wednesday, the 4 boys may be with dad, while the 4 girls are with mom. And then on Thursday, Friday, and Saturday, they switch up and the girls go with dad and all the boys go with mom. And so that would be a split custody situation. There's also, in some jurisdictions, grandparent custody and visitation. And so sometimes when there is a custody battle, the grandparents may intervene in the divorce action, and they may also request grandparent visitation. Now, there's also a non-parental custody, and that's where the state has custody, and that's generally where the custody has been removed from the parents. Now, one thing to remember, and a lot of people don't believe this, they think that something else is the case because of their personal experience or because of stories that they've heard, but custody determinations are supposed to be by law sex and gender neutral decisions. And what do I mean by that? Basically, the decisions regarding custody should not be made based upon the sex of either parent. And so therefore there should not be a dynamic where women are always getting custody simply because they are women, or men are denied custody simply because they are men. That is not the way that the process is supposed to work, and generally it does not work that way. Oftentimes what happens is that an individual fails to request custody or request visitation, and therefore they are not given such. But when all things are pretty much the same between the mother and the father, and there are no real serious issues such as domestic violence, the courts will generally try to make sure that both parents have abiding contact with the child, and that parental alienation does not set in terms of a child being separated from either parent for an extended period of time. And the government has some information regarding the test that is used in custody determinations. And I think most parents don't realize that there is actually a test that courts use in determining, what should happen to the children. And so we're going to go over that so that you have a better idea of what the court is actually considering, because sometimes a judgment in a custody proceeding may not make sense to the parents, but after this you'll have a better sense of exactly why courts make the determinations they make and what things they are considering, what kinds of evidence are they weighing. And so basically there's no standard definition of the best interest of the child. So each state looks at it slightly differently. However, there is a sort of a general umbrella under which the states are operating. And so the test for custody is what is in the best interest of the child. Now, that's with a parent versus a parent. When there's a situation where, for instance, the state is taking custody, what the state looks at is often the adequate care. And so they look to see, can the parent or parents provide adequate care with assistance in order to take care of the child. And so they want to consider that prior to taking custody away from a parent who just may be a vulnerable parent who may not have the caregiving skills that they need. But when we're talking about parent versus parent, it's just the general best interest test. And again, it varies from state to state. And so you can see that it says approximately 22 states and Washington, D.C. list specific factors in their statutes for the courts to consider when they are making these determinations. And so they look at things, this is just sort of generally speaking, we're going to look a little bit deeper at this, but they look at things like emotional ties and relationships between all parties involved. They look at the capacity to provide a safe home for the child with adequate food, clothing, and shelter. There goes that adequate care test there. They look at the mental and physical needs of the children and the parents. And they also look at issues like domestic violence, and domestic violence can be a big one in terms of altering what would have been the normal course in terms of a custody determination. And here you can see Georgia's code regarding child custody, and then you can see California. And Georgia actually has, a pretty standard way of looking at the best interest test. So they're looking at the child's relationships related to home, school, and community. They are looking at the child's community ties, including church, school, and friends. They're looking at the child's background and ties. They are looking at what's going to be the least disruptive placement in terms of, where the child is going to go. They look at the uniqueness of every family and child. So it's going to be different. The court may make one determination for one child in the family and a totally different determination for another child in the family. They look at the parent's wishes and the child's wishes, and often when the judge does that, the judge may take the child into chambers and talk to the child individually to find out what the child actually wants. And they generally are not going to share that with the parents, but they want the children to have the opportunity to be open and honest about what their wishes are and why they see things the way they do. And there's often in some jurisdictions a guardian ad litem appointed that assists the courts with making the determination. And a guardian ad litem is basically the legal entity that works for the best interest of the child. Now, this is different from a child's attorney, because a child's attorney represents the wishes of the child, like the child's desires, but the guardian ad litem steps in the shoes of the child and actually requests the best interest of the child. And it may not be consistent with what the child's attorney is requesting, which would be the child's wishes. And so you have a couple of different attorneys that are often present. You often have the mother's attorney, the father's attorney, the guardian ad litem, and sometimes the child has an attorney appointed for them. And as a recap, remember, the courts are looking at the preferences of the parents, the preferences of the child, who was the primary caregiver. This is another big issue. The primary caregiver is the person who has been taking primary care of the child. Now, sometimes this, of course, is not going to be favorable for the dad, because oftentimes when there is a stay-at-home parent, it's going to be the stay-at-home parent mom. And so that mom ends up being the primary caregiver. But the courts also take into consideration, if the father has been the primary breadwinner, that the father couldn't have also been the primary caregiver. So the courts do take all of that into consideration in terms of coming up with a fair agreement for the child and the parents. Again, looking at the health of all of the people involved in the child's family, including people that would have contact with the child that may not immediately be in the family. Again, looking at the attachment to community and family, also looking at any special needs that the child may have. And of course, this may go back to the primary caregiver again. So if the child has some significant special needs and the primary caregiver has been the one tending to those needs, that actually may weigh heavily on the court. And they also look to see, which parent is likely to support the custody order, because you have some parents that will try to circumvent the custody order. And so the courts are interested in who's going to be most supportive in terms of the child having access to both parents. There's also a look at domestic violence history. And if there is a domestic violence history involving the child, that definitely weighs heavily on the court. You also have parental adequate care capacity. And one of the other things that the court wants to know about is there any plan to relocate? So if someone is planning to relocate out of the jurisdiction of that family court, that also is going to weigh on the court's decision. So now you know what the best interest of the child test is. You know the different types of custody. You know the different forms that it can take. You know what custody means. And so now you are armed with language to have conversations regarding custody and your wishes. And so if you have any specific questions regarding custody in your own personal situation, you are encouraged to seek the counsel of your private attorney. Remember, knowledge is power. Take care and see you soon.